Hey all, I'm here today on Constitution Day, 17 September, the year 2021, to talk about vaccine mandates and the U.S. Supreme Court. It's kind of topical. And it involves the U.S. Constitution, more specifically, the Due Process Clause of the 5th and 14th Amendments that states, broadly speaking, that the government cannot deny you your life, liberty, or freedom without due process of law. All right, so the case I want to talk about is Clausen v. Indiana University Board of Trustees, 2021, decided quite recently by a federal judge, trial court judge, put on the bench incidentally by President Donald J. Trump. They were looking at, the court was looking at a vaccine mandate by Indiana University for students that stipulated that students had to get a vaccine prior to attending school on campus. And if they failed to get one and didn't qualify for one of the exemptions, they would be denied the ability to register for classes, have their email revoked, and some other administrative penalties. All right, so some students appealed that ruling, appealed that policy to a federal court in Indiana, southern Indiana, and ultimately that court. Now, so here's kind of the procedural issue. It is a procedural issue, at least at this stage of the litigation game. It is the students were asking for a temporary emergency injunction to halt the policy immediately so that they could register for classes for the current fall semester. The court did reject that emergency ask for an injunction. Recognize that the bar for those sorts of claims is quite high, as it should be. Litigants making that sort of a quick claim for an emergency injunction have to meet a really high burden of proof, basically to show the likelihood that they will succeed at the end on the merits, on the substance of their claims. And the court didn't see it that way. They thought, in fact, the students were pretty unlikely to succeed in the end, and so they rejected the claim for a temporary injunction, emergency injunction. All right, so recognize that, because even now the case is still alive. And it's working its way up, I'll get to that in a minute, to be decided on the merits. Okay. So recognize that. Well, let me just follow up with that right now. So the students lost, right? They appealed it to the Seventh Circuit. The court rejected that appeal. And then Indiana asked the Seventh Circuit to dismiss the case entirely, and the Seventh Circuit declined to do that, meaning that the court, the Seventh Circuit Court of Appeals, I think a 3-judge panel initially, will look at that case, I believe, on the merits. I'm not entirely sure. I'm not an attorney. Don't take legal advice from me. It's possible it could go back to that same judge to be decided on the merits, and then go from there, kind of a situation. So it's still sort of in process, and we'll see. But we have a preliminary ruling by the federal trial court here, Clausen v. Indiana University. So the court rules very briefly here that there's a compelling public health rationale, and it outweighs the students' legitimate liberty interests under, in this case, the 14th Amendment's Due Process Clause, because that's what it says, right? No state shall deny life, liberty, or property without due process of law. So it's a classic 14th Amendment state action sort of a situation. So the court notes, and again, not incidentally, but this gets a little in the weeds and a little technical. Now, the court does say that this is going to be decided under what's called rational basis review. There's 3 levels of review for the 14th Amendment. It is strict scrutiny, intermediate scrutiny, and rational basis. The rational basis review level is the most relaxed one, the one most deferential to the government. And in the view of the court, for reasons that I'll make clear in a moment, they said this is going to be a case decided under the rational basis standard. That really the litigants in this case, the plaintiffs, the students, would need to show that the policy of Indiana University is not rational. It's a tough standard. The other two categories of review, intermediate scrutiny and strict scrutiny, the burden of proof is on the government to either show that there's an important interest at stake or there's a compelling interest at stake. Here the burden is actually on the plaintiffs to show that the policy in question is not rational. And the court says, well, it's eminently rational based on the current COVID-19 pandemic and the effectiveness of the vaccines available to Americans and the low rate of negative consequences for the vaccine. The state easily meets that standard of defending it as a rational policy. And the court even suggests that it's actually a pretty compelling one. They do note that there are going to be boundaries here, that the government cannot endlessly claim that there's a pandemic. But as long as conditions are, especially now with the Delta variant, right, as long as the pandemic is still raging, this is an entirely rational policy by Indiana University, which incidentally is where I got my PhD all the way back in 1991. Go Hoosiers! So, the court weighs the policy as being eminently rational, probably even compelling, in the context of the current pandemic. And they note that Indiana also allows exceptions, right? Religious and health exceptions. There are some, right, for whom it is medically inadvisable to get a vaccine. They can apply for that exemption, or they can apply for a religious exemption. It makes it even more defensible as a policy. All right, I think what else I want to say here. The court also notes, although it's not ultimately germane to their ruling and not really germane to the due process clause, but I thought I'd mention it at least in passing because it's kind of interesting and relevant in a broad sense. The court does note that the Indiana legislature passed a law recently stating that no government agency can require a vaccine passport, which is really not a great term because this is really not a passport in the traditional legal sense of what a passport is. But anyway, proof. You shouldn't. The government cannot require that you provide proof of vaccination. So Indiana notes, we're not going to be requiring proof in terms of a card or anything, but we are going to require that students fill out an online form. And if it can be shown later that they lied on that form, there can be quite severe administrative penalties, i.e. disenrollment from the university, and perhaps a ban on ever coming back. I'm not entirely certain, but fairly severe administrative penalties. That's a little blip there in Indiana because of their, Republicans control both the state legislature and the governor's mansion, so they have that kind of a law in place, as other red states do. And what the federal trial court holds here is that really our key precedential ruling to rely on here is Jacobson v. Massachusetts, 1905. An oldie but goodie. The court here holds that, hey, in Jacobson v. Massachusetts, the Supreme Court upheld as rational a mandated vaccine at the local level, but authorized under state law for a mandate to get a smallpox vaccine back when smallpox was raging in America. So, and in that case, there were actually criminal penalties if you didn't get the smallpox vaccine, and with very limited exceptions, only for kids, if it could show that they had a health problem that wouldn't allow them to get the vaccine. Adults had no such exemption. So for adults, universal. And I would warrant here that the smallpox vaccine much more dangerous to the recipients than the current COVID-19 vaccines, which are remarkably safe. So the court upholds that as a legitimate pursuit of public health by the state of Massachusetts, and in this case a local government entity, and they even permitted the use of criminal penalties. Now not jail or anything like that, but I think a $5 fine Now, $5 back then, I don't know, if you take into account inflation, what would that be worth today? I have no dang idea. But $5 back then would have been significant. That was over 100 years ago. Would have been a significant fine. The federal court here also notes, hey, look, in a sense, there's nothing new here, right? That especially educational institutions, both K through 12 and higher ed, they have long required proof of vaccination for all sorts of diseases. So this is hardly a novel sort of a claim by Indiana University. Hardly a novel claim. Not novel at all. So the court also cites that as a reason for their ruling here. Although again, remember, it's a procedural ruling only. So let's be cautious here. It's a procedural ruling only. And the Seventh Circuit Court of Appeals is allowing the case to go forward on the merits, right? The court has not yet decided. No federal court has yet decided on the merits of the vaccination mandate. They've just denied, right? Petitioners ask for a emergency injunction. And again, that requires an extra high burden of proof on the plaintiffs to show that they are likely to prevail in the end. And all I would say, though, as someone who's studied an awful lot of cases over the years, I think at least the federal court, at the trial court level, that federal judge, the one put there by President Trump, he really seems to telegraph, right, where he thinks is going to come out in the end. He seems beyond skeptical about the ability of these students to win their case. That's what the court has held. That's what the Supreme Court has held. If you go back to that key precedent from 1905, or Clausen v. Indiana University Board of Trustees, 2021, that, there is, the court does acknowledge in the current case, they do acknowledge that these students have a legitimate liberty interest at stake, that there's a legitimate due process claim here, that they are being denied their liberty to some degree. But ultimately, they say that the public health rationale is plenty heavy enough to outweigh this legitimate liberty interest, right? Because that's what the Constitution often involves, right? Sorts of competing claims, and then the courts are left to balance them in a way that seems to make sense. Okay, so I'm going to leave it there. There's a whole bunch of cases in all sorts of areas. That would be a much longer conversation on the due process clause, but that's one of the most important parts of our Constitution. The one string of cases that comes to mind quickly, and then I'll finish with that, unrelated to vaccine mandates, but just to give you a little more, shed a little more light on the due process clause of either the Fifth or 14th Amendments. It was the Fifth Amendment's due process clause that the Supreme Court used by a bare majority, in every case, to undercut President George W. Bush's, what were they called? Those commissions, those military commissions that were being used to try detainees at Guantanamo Bay post 9/11 and the War on Terror. And these were not even U.S. citizens, right? And they were seized on a foreign battlefield and placed at Guantanamo Bay, which technically, right, is part of Cuba, although we forcibly lease it from them in perpetuity and use it as a military base. I think the George W. Bush administration was being too clever by half, at least in the view of the court, by saying, well, this is not even America, this is Cuba, so the federal courts don't have jurisdiction. And the Supreme Court said, oh, that's not correct. That's too clever by half. Guantanamo Bay is effectively U.S. territory, just like military bases around the world that are U.S. are U.S. territory. I think John McCain, fun fact to know and learn, was born on a military base in what was then Western Germany. And some were saying, well, he's not native born, he's not an American citizen, therefore he can't run for president. That argument didn't go anywhere, nor should it have. So the court applies the same logic here. It's a military base, U.S. military base. That's U.S. territory. We control it in every sense of the word. Anyway, now these military commissions, the court said, were inadequate. Did not accord the defendant adequate tools to defend him or herself, and the prosecution was given all the advantages, kind of like a form of kangaroo court, where the outcome would have been predetermined by the rules of the game. And the Supreme Court ruled, although it was 5-4, they ruled that yeah, we have jurisdiction, and this is inadequate due process. You're not giving these detainees adequate due process. Now look, they don't necessarily deserve access to a federal trial court in the U.S., an Article III court. That you might want to do that. And later presidents actually did some of that with some success. But they said, you can do that, but you don't have to. You can definitely use military commissions to try these people, but you got to make the rules fairer so that plaintiffs can really defend themselves. That's what the Due Process Clause requires. Even if they are not Americans, they still get some due process protection. Not the full Monty of protection, but significant protection, because the Due Process Clause, the Fifth Amendment says that persons get this protection. So you don't have to be a U.S. citizen to get that protection from the U.S. government. It applies to the U.S. government, whether it's dealing with Americans or foreigners. So I will leave it there. So hopefully that sheds a little useful light on how the Supreme Court, in a few cases, has thought about the Due Process Clause, both the Fifth and 14th Amendments. Thanks all. Take care. Be safe out there.